Good morning. How are all of you doing? So you've got the basic, the startup of it, and now let's start talking about some of the meat of the NAS report and some trends that are occurring. The first thing that we want you to know, that you need to learn, is this is the book right here. This is it. You go to Google, look up National Academies Press, and you order the book. $32, but if you buy it on a holiday weekend, it's $26.25. And here's the great news. If 5 people in this room buy this book and mention my name, I get a dustbuster. So this is the book. You've got to read it, because this is the Bible for us. And when you do the chronological history of the advancement of reform for forensic science in the United States, there are only 2 points in history you need to know. The first was when Moses came down from the mountain with the 10 Commandments. And that set the stage for law. And then you fast forward in history, and God said, I have a present for the defense bar. And here it is. This is it, right? I carry this around with me pretty much wherever I go. I've given away a lot of copies. This is the book. And when you have a problem and you don't understand it, the good news is it's in here. The second good thing for this audience to know today is that you don't have to start from zero, which is where we started, in February of 2009, when the vast majority of the defense bar had no idea what hit them. Now we have resources. And, the NACDL's Resource Center with Vanessa at the helm, you make a telephone call, you can get the motions, you can get the backup, you can get the people who are the experts. This is phenomenal. When I started in law almost 40 years ago, a zip drive, we thought that was a gun used by gang members. Times have changed, so you have great resources at your command. Now, the first thing we need to know about forensic science is it's different from science. Science is real. Science involves things that you all studied: chemistry, biology, geology. Those are sciences. They are based upon experiments, upon the scientific method, upon independent research going back hundreds of years. When Copernicus aimed that telescope up into the sky, he was using the sciences of magnification and glass to see the universe. That's science. Then there's this other world. That world is called forensic science. That's different from what we do. That's a whole other world. Chris isn't kidding when he talks about fiction, because what they do is not science. And you'll often hear me say, I no longer talk about a lot of these forensic sciences as sciences. I call them disciplines, because they are not sciences. Hair analysis is not a science. Fingerprint analysis is not a science. Arson investigation is not a science. Because the dirty little secret that had been kept from us, that we didn't catch on to, and that the NAS report reveals, is that what they're doing, and have been doing for almost 100 years, is engaging in subjective judgment. And that's going to be one of the goals of the cross-examinations that we want you to come away from the next 48 hours. That's what that comparison business is all about. It's about subjective judgment. And when something is subjective, that goes against everything that we were taught from the first day of law school until this moment in time. You will be a lawyer. You will be objective. You will have no emotions, no feelings. You will be a lawyer, right? Objective versus subjective, 2 completely different things. So the first thing to know is science versus disciplines. Secondly, there's a huge difference between science, studying, how what is the composition of blood, or what are the layers of epidermis, what are they made up of? That's science, that's biology, that's chemistry. But this pen, This ain't science. All this pen is an application of science. Huge difference. When these guys take the witness stand and they say, I'm a fingerprint ridge analysis comparison person, they're talking about the application of science. And a lot of them now, because of the NES report, they don't say they're scientists anymore. They did for 100 years, but they've stopped doing that. And the reason they stopped doing that is because they know that you're coming. They know that the cross is here. They know that in 5 questions, you can say to them, you're a scientist. Really, what is your science degree in? I don't have a degree in science. Well, how is it that you're a scientist? Didn't you say that a few minutes ago during your qualifications as an expert? Which we didn't challenge, by the way. I don't challenge qualifications for experts. It's a losing cause. Most of the judges are going to let them be qualified because they've already testified 100 times. They've been qualified by other courts. Why would this judge embarrass his colleagues? So they're going to testify. I'd rather let the qualifications come in and then cross-examine on them. Because by the time you get through with that cross-examination, this person's not a scientist. They may be an exterminator. They may be a dust collector, but they are not scientists. And a lot of them realize this now when you go to conferences of police organizations and organizations where there are a lot of these technicians. They now say, I'm a technician, or I'm a fingerprint ridge analyst. I'm an analyst. All of you are familiar with analysts. You all have therapists, right? You know what I'm talking about. So that's where we're at with these guys. Now, we know that fingerprints, for example, involves biology. This piece of finger, we can look at it through an electron microscope. We can find that it has an atomic structure. We know that's based upon mathematics. We know it's based upon physics. Fingerprint analysis, however, is a completely different subject. That's based upon a subjective judgment that I can take a look at a known inked fingerprint and compare it to a smudge known as a latent print. Now, let me ask you this question. How many of you in this room have ever looked at a latent fingerprint, a smudge? Quite a few, right? The smudge is nice and clear, right? Because you know our clients, when they're jumping out the window, they stop for a minute and say, excuse me. Right? They don't do that. At least not my clients in New York. They're moving pretty quickly. And so they don't stop to do, they do one of these, right? These smudged fingerprints are a joke. They require a subjective judgment in the very first instance. You have to first say to yourself, I think there's enough of this smudge that I can make an analysis. And by the way, because I'm a fingerprint analyst, I don't even have to document that. I don't have to write it down. If I gave you $500,000 and I gave you the best lab in New York, Rockefeller Center University, the university in the world for stem cell research, and I gave you $500,000 and said, find a cure for lumbar cancer. You know, with that $500,000, if you take a beaker off the shelf in the storage room and you move that beaker 20 feet to the lab bench, you have to record it. You know why you have to record it? Because in science, we want to be able to replicate and look over the work that you claim you did. That's science. In forensic science, we don't want documentation. What we want in forensic science is for you to cross-examine me, the forensic expert, on the fact that I say it is so, therefore it must be. And documentation? Please. Here's my final report. And what does that final report say? It says, it's a match. And you're stuck with that. It's a match. A match of what? Why are you asking so many questions, Mr. Schechter? Move on. Right? So let's be really clear about what these things are. In arson investigation, one of the great shibboleths of all time, in arson involves a fire. Fire involves chemistry. It involves physics. It involves subatomic theories of particle manipulation. A fire is a scientific phenomenon. It can be studied. What can't be studied is when somebody takes the witness stand and says, I've been living with Billy, my dog. He's my accelerant dog, and we have a very close relationship. I'll tell you how close our relationship is. It's so close that when Billy smells kerosene, his ears go up and his eyes look at me, and I know that Billy's telling me this was a fire. Now, some of you laugh, right? Who could you ever imagine such testimony in a court of law? Is that possible? Somebody would dare to do that with a straight face in a federal court? Yes, it happened. Famous case, United States versus Hebshey out of Massachusetts. Judge Gertner, 2255, ineffective assistance of counsel, talked about the testimony of the dog handler of Billy, who, by the way, sua sponte, without being asked, the dog handler said, Billy is no longer with us. Okay? Now let me tell you something about that. If you don't think that happened, and if that how ridiculous that is, not only did that happen, but there was an eyewitness to that testimony in this room. It's Jean Kempthorne, sitting right here in the front row. Some of you are going to be very lucky to have her in your group. Jean did that case, and she knows every piece of that testimony inside out. That happened. That kind of stupidity and ignorance led to a man being convicted and going to jail. And Jean told me that he's finally out. It's over. Because it's never over, as you and I know, to have to go through that system. You're scarred for life. You never walk down the street the same way. You never relate to your family the same way. Here's the all-time best in one of the most jaw-dropping moments of testimony before the NAS committee. We had the testimony of David Sen, who is the father of human bite mark comparison. This is my personal favorite. You know, I know some of you are into fingerprints, some of you love tool marks, a lot of you like that blood spatter stuff. I like human bite mark comparison. Is there anybody in the room with a human bite mark case? Anybody had one? You had one, right? Christine? Anybody else? You had one, right? Great, great stuff, right? The whole theory of human bite mark comparison is, in certain violent crimes, particularly sexual crimes, the victim ends up getting bite marks on his or her body. And these bite marks are quite telling. It's part of the violence of the act. And the way this has worked for over 50 to 65 years has been, the expert takes the witness stand and says, I've examined the bite mark, I've examined a denture from Mr. Schechter's mouth, and I, as the expert, can positively tell this jury that that bite mark came from Schechter's mouth to the exclusion of all other mouths, not in the United States, not on this planet, but in the universe. That's Schechter's bite mark. Pretty amazing, huh? Okay. So David Sen did this whole thing he did slides, he went through this whole thing for 20 minutes before the NAS committee, and he said, that's human bite mark comparison, and I'm the father of it. Then he said, and I'll never forget this because I was taking notes at the time, I was looking down, and he said the following. Now, everything I've just told you has never been proven. There is no research, there is no documentation, this has just been around. And I'm like an idiot, I'm writing, there's no proof, there's no documentation, right? Then it occurred to me, wait a minute. So he finished the presentation, I raised my hand and I said, excuse me, did I miss something? Did you just say that there's no basis for this? He said, yes. I said, haven't you been going around the country testifying that the guy at the defense table, it's his bite mark? He goes, yes. I said, you're not going to do that anymore, are you? He said, no. So, you know, progress, right? Now, what don't we have in these forensic disciplines? What is missing? Well, Chris has already given you an outline of what's missing. And that's part of what cross-examination in the forensic science is about. What's missing? What they don't have. And they don't have it because they can't claim it because it doesn't exist. For any of you who watched a recent unwell-publicized trial in Florida, a brilliant summation by the defense attorney. Anybody seen Mr. Baez's summation in the Caylee Anthony case? It consisted of a flip chart. It was a flip chart. And in flip chart number 1, he had a title that said, "No evidence." That was the title. And underneath it, for 10 pages, he went through what they didn't have. No chloroform, no receipts for chloroform, no DNA on the duct tape, no purchases of the duct tape, nothing on the duct tape, no spit, no saliva, no fingerprints. And after 35 minutes in the middle of his summation of going, no, 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 and those 2 idiots at the prosecution table sitting there laughing, the last laugh was the jury's laugh. Last laugh was the jury's laugh. And I take time out on the Caylee Anthony case because just as Mr. Baez won that case, one of you sitting here today, 10 of you sitting here today, are going to win your case. Because this stuff is easy. This is tailor-made for us. It doesn't get better. This is easier than doing a motion to suppress. Motion to suppress is hard. You know, we don't have the 4th Amendment anymore. I mean, it's in the Constitution, but we don't have it. But this stuff, this has got so many holes in it, it's tailor-made for cross-examination. So, there are no standards. That's one of the big problems. Why is it that in upstate New York versus downstate New York versus California versus Indiana versus Wisconsin, there are no standards for doing a fingerprint comparison? What I consider a whirl here in Mason County is not what is considered a whirl in California or in Oregon. What I consider a flowing ridge mark in Brooklyn, New York. You've heard of Brooklyn, right? That's where I'm from, Brooklyn. Right? Brooklyn, we have fingerprints. Right? We'll sell you fingerprints. Right? Fingerprints in New York are different from fingerprints elsewhere because there are no standards that define what is a whirl, what is a ridge, what is a bifurcation. There are no standards for the number of comparisons you have to have. One of the things that the fingerprint analysis people are doing now is they're running away from saying points of comparison. They've gone because they know we're coming. We're killing them on that. So now they go, I looked at different areas of the fingerprint. And as you can see in this area, these 3 green dots, well, they match these 3 green dots, right? Well, you can cross-examine on that. We know you can do that because after you do the green dot cross-examination, then you do your summation. And you tell the jurors, do you think that my client can be convicted on the basis of these green dots? And hold up the green dots. And tell the jurors, take a look at the green dots in the jury room. And they will come to the same conclusion you did, that those ain't the same 3 green dots, or those green dots do not juxtapose with one another. One of the big things in fingerprints is that, and the NAS talked about this across the forensic disciplines, are unwarranted assumptions that have never been tested. What's the biggest unwarranted assumption in fingerprints? You know this. What? Say it again. No 2 are alike. No 2 fingerprints are the same. How do you know that? You ever ask a fingerprint guy, how do you know that? Can you tell me the 2 studies? Tell me 2 studies. Not 1, 2. 2 is too difficult. Give me 1. I want 1 study that tells me that no 2 fingerprints are alike. Well, Mr. Schechter, everybody knows no 2 fingerprints are alike. I once had an investigator for legal aid tell me that. I was going to put him on the witness stand. So I asked him that question. This is 35 years ago before I got involved in this. He didn't know. I said, what's the deal here? He says, well, everybody knows that. I said, I don't know that, but I'm from Brooklyn. What do I know? So here's the deal. Just because somebody says it's so doesn't mean it's so. There's a professor in California, Jennifer Mnookin, who we quote from in the NES report, who raises a much more intriguing question. Can partial fingerprints, a partial fingerprint, be similar to somebody else's partial fingerprint? How about that? How about we do a study of all people born between 1940 and 1979 in the southwestern corner of Croatia to similar families to see if the left corner of the index finger is a similar fingerprint Just that little left corner on several people. Do you know the answer to that question? The answer is no. You know what? Why no? Why do you say no? Emily, right? Why do you say no? Because she got it. There's no study. No one's ever tested it. So how do we know partial fingerprint's not the same? We don't know. It has never been tested. Now, another area for cross-examination that the NAS report talked about in depth, bias. As early as Newton getting hit on the head with that apple and Copernicus, scientists have known that bias is a big problem, that you can come to certain assumptions based upon your own internal beliefs and prejudices. And so in the real world of science, we test for bias. We look at it constantly. We go over it. We make allowances for it. We focus in on it. We have our colleagues look at our work to see if the assumptions we made, which are recorded in our logs and our notes, if those biases exist. In the world of forensic science, until the NAS report came out, nothing about bias. It doesn't exist. And you know why it doesn't exist? Because we're law enforcement. We're fair. We're just. Biased? Us? No. Can't be. So as a result, bias was not part of the groundswell of forensic disciplines that arose over the last 100 years. And what are these biases? They're obvious. You have these biases. We see them all the time. There's cognitive bias, where you ignore base information in assessing the probative value of a particular item. This comes up remember in Atlanta years ago, there was a serial murderer who they finally caught. Big case. And the reason they caught this guy was they came to the conclusion that carpet fibers found at the scenes of some of the murders matched a carpet in this guy's house. There was only one problem with that theory. That carpet was in your house, and in your house, and in your house, because that piece of carpet was manufactured by millions of yards by one manufacturer. It was sold in Walmart, for God's sake. If it's sold in Walmart, it must be good. So that's an example of cognitive bias, where you take a base assumption and you expand it outward and reach a conclusion of identification. Cognitive dissonance. This is where your conclusion is so good to yourself. You pat yourself on the back. Your conclusion is so wonderful that you don't have to accept new information. Classic example of this. Brandon Mayfield that Chris referred to. I mean, here's a guy who's never left the state of Oregon, making 60 grand a year. He's got a small practice, and he gets linked to a bombing in Madrid. And 3 FBI scientists and 1 defense expert all conclude that that fingerprint is the same as the fingerprint on the knapsack found at the Madrid bombing. And when the Spanish police said to the FBI, you know, we're looking at this, we don't see it. Where's the comparison? And the FBI said, excuse me, we're the FBI. Not only did, and you'll hear this on the witness stand. It's one of my favorites. We train at Quantico. We're Quanticoans. Some people in the room might think Quanticoans is a lost tribe of Israel. We're Quanticoans. We know, and you don't. And so cognitive dissonance says, I don't care what you think. I'm right. That doesn't happen in the real world of science. A real scientist will always say, honestly, I think I'm right. I'm pretty sure I'm right. I've done it 1,000 times. I've replicated. But you know what? Because I'm a scientist and because I believe in what I do, and you're a scientist, check my work. Check my work. It took us 100 years to get the FBI to accept blind verification of fingerprint analysis. Until that time, this is astounding when you think about it. I do a fingerprint, I reach a conclusion, and the guy who's been sitting next to me for 20 years, Chris McKee, on the same bench, we're buddies. We grill hot dogs on July 4th, for God's sake. Like, Chris, take a look at my work. It's right, isn't it? You're absolutely right, Marv. I mean, right. Well job. Good job. How stupid is this? And now when you look back, the FBI says, we think blind verification is an excellent way to do things. And the reason they think that is because of you, because the defense bar has now caught them at this game. The question is, how much further can the defense bar go? So that's bias. By the way, when you read the book, there's a number of references in here to the work of a man from England. His name is Itiel Dror, D-R-O-R. He's a spectacular scientist who was not into forensics at all. He spent most of his life teaching U.S. fighter pilots how to react to missiles coming at their supersonic airplane, how to react quickly to get out of the way. And he sort of stumbled into this one day, and he read some report, and he said, this is ridiculous. People believe this stuff? So he devised an experiment where he brought a bunch of fingerprint analysts into a room, and he didn't tell them why they were there. They were not told. They just came in, and he said, I'm going to hand these out to you. And he handed out to one group a set of fingerprints, and he had another group, which was the real group he was after. He handed them a set of fingerprints, and he said to the second group, I'd like you to analyze these fingerprints and tell me, is it a match or is it not a match? And as he was leaving the room, he turned to the fingerprints. He said, by the way, this guy's a serial rapist and he's in custody, but he may get out. And he walked out. Pretty clever, right? So that's the introduction of the bias. And he wanted to see what would happen. When they examined the work of those fingerprint guys, 6 out of the 24 technicians had changed their opinion. Dror forgot to tell them that the work he was giving them was their own work from 5 to 7 years previously. And 6 of 24, that's 1/4, 25%, changed their opinion, and when they had said previously not a match, it now was a match. That's an astounding experiment. And I think, I'm pretty sure about this, one of the fingerprint guys who he gave this material to, he gave that technician his own fingerprints. Pretty clever, pretty clever. This experiment has not been refuted. This experiment is being expanded. Chris referred to it as the Mnuchin, $800,000 to study fingerprints. We're going to find out just what fingerprints are made of or not made of. Now, one of my favorite areas for cross-examination, and it comes up in this case file. Gene had this in the Hebsche case. You have it in every case you've seen. Every forensic case I've ever seen, you end up with a piece of worthless discovery called the final lab report, which has nothing on it, absolutely nothing. But it does contain some interesting things. This was what the NAS heard about report writing. 1, there are different terms to describe the conclusions of the different technicians in the different fields. So here's my list. This is Marv's top 100. I'm going to give you the language that we heard from the mouths of these technicians. The first one, it's a match. It's a match. Well, what does that mean to juror number 7? Well, it means it's the same person, right? This is the fingerprint. It must mean the guy sitting at the defense table. Here's another one. It is consistent with. It is consistent with. What the hell does that mean? You know what that means? It means that the technician's not 100% sure, but he's going to have his cake anyway. And he's going to imply to juror number 7 that it's the same fingerprint. So it's consistent with. And one of the things we need to spend some time on in cross-examination is, define for me, sir, the term consistent. You'd be amazed at the answers you'll get. Some people think you said the word custard instead of consistent, right? Here's another one. It's identical. That was used because they got tired of saying match. So they said identical. That's a word that jurors can relate to. This fingerprint is identical to this fingerprint. You see, that shows that not only am I a technician, but I'm a man of the people. Okay? Again, we're trying to influence how the jurors are thinking. Now it gets a little dicey. It's similar in all respects tested. It's similar in all respects tested. Now, what the hell does that mean? You mean it's not similar in some of the respects? What respects were tested? Were some respects not tested? By the way, can you define custard? Right? That's a good one, right? But here it is. You ready? The all-time #1 hit parade report writing scandal of the year. It cannot be excluded as a source of. It cannot be excluded as a source of. Juror number 7 sitting there going, don't I have tickets for the Mets game tonight? It cannot be excluded as a source of. What the hell is that about? I know what that's about. That's about sowing confusion. That's about being able to get across to the jury that it's the identical fingerprint. It is the same cartridge to the exclusion of all of the guns in the universe, but you don't have to say it. Or you can say it in language that's so flowing and mellifluous and scientific that the jurors will buy it. When the NAS heard this, the scientists on the NAS committee, after 6 months of hearing this, they said the following: we've never heard this before. Because they were real scientists. You know, they said, we've never heard this before. What kind of language is this? I said, well, I was one of 2, there were 3 lawyers on the committee. I said, well, this is the language we sort of use in the court system. They said, well, we don't use this language in real science. So then they pondered this question: why is it that this language exists? And here was the answer. It's a great answer. It exists because there is a paucity of research that has been done in this area, in all of the forensic disciplines, on what constitutes sameness. And because there isn't a solid ground of literature, the technicians at the bottom cannot express in a scientific language what the consistency is. That's the problem. And I really have cleaned that up. When I say the person at the bottom, I've met these technicians. Some of them are right out of law school. Some of them are right out of Indiana University. It's their first job. So who tells them? Who tells them how to write these reports and use this language? Well, the supervisor. And who's the supervisor? Well, the supervisor's been doing this for 25 years. And who did the supervisor learn it from? Well, he learned it from the guy from 45 years ago. And that's how this gets carried down and on. And interestingly enough, this business of language and report writing has now spilled over into the second big area that I wanted to talk to you about today, which is after we do a cross-examination which hones in different ways on subjectivity, the next big area is probability. Probability. Because if we are right in the defense bar, and if the NAS report is correct, then it's not about a match. As Chris said, in real science, it's absurd that there could be no error rate. It's absurd. Even DNA, on its best day, is expressed as a probability. It's a huge probability. It's been a tested probability, but it is a probability. This is Schechter's DNA to the exclusion of 1 trillion, gabillion, gazillion to the 75th degree. But that's a probability. Now, here's the real big battle that's coming. The IAI, which is the International Association for Identification, it's one of the biggest groups in the United States that certifies and runs programs in all these different disciplines, and disciplines you've never heard of. You know, there's a whole discipline on sneaker comparison. Am I dating myself? Sneakers? Does everybody still call it that? You know, where people can get on the witness stand and say, the sneaker that made this tread at the crime scene, that sneaker is Marv Schechter's sneaker that we found at his house. There's a whole course on it, and you can get certified. And you can take the witness stand and say, I'm certified by the IAI. Last year, the IAI did something astounding, incredible. Some of us couldn't believe it. Some of us still don't accept it. But they said, for the first time, it was torturous language. You can imagine what the battles must have been inside the forensic discipline community, the IAI. But they finally said, look, from here on in, when you're doing fingerprint analysis, you can only express your conclusion as a probability. You cannot say it's a match anymore. That's it. That's finished. So that was a huge change. Now, here's the good news, and here's the bad news. The bad news is that at the state court level, we're getting killed because the state court judges don't know this. The prosecutors know that the state court judges don't know this. Therefore, the prosecutors make stupid, moronic arguments. You cannot get caught up in that. You have to educate the judge. And fortunately, we have great cases that have come down, and they're in your materials. But here's where we're at this morning in 2011. Federal courts and some state courts are now excluding completely this kind of testimony on the grounds that the person's not qualified, on the grounds that there was no documentation to back up the testimony, therefore I'm not going to allow it in. What you're saying, sir, even though you're qualified, is speculation. Right? You cannot say that a person ran up the stairs, stuck their fingers out onto a patio, tried to re-enter the building, and that's how they got burns, which are consistent with a person who would set a fire. One judge out of Paducah, Kentucky, a federal judge, said, I don't think so. I don't see where your opinion is based upon any science. In fact, there is no science to back your opinion. In fact, you said so. I've looked at your scientific work, and you didn't even prove that. So the courts are not allowing that. By the way, discovery in the federal courts and state courts, I know it's very different, but generally the common denominator in most state courts is no discovery. Or if you get discovery, it's very limited. Some of the federal courts are now saying, if you don't give the discovery to the defense in a timely fashion on this forensics, I'm excluding the testimony. Big case, United States versus Malzone. That was the recommendation of the magistrate judge. Not allowing you to present this testimony. Trend number 2, I'm going to finish up with this. The big trend in the federal courts, and it's going to work its way down to the state courts, but that's where you all work, in the state courts. So this is why we need to challenge this stuff and cross-examine much better on it. Limiting the testimony. Here the judges have gotten very smart. Instead of refusing to qualify the expert, which, by the way, it didn't take much to qualify an expert. So a federal judge says, why should I disallow this person testifying and then get reversed on appeal? A lot easier to say, you know something, Mr. Schechter, you're an expert. You can be the expert. That's fine. Now let's hear what you have to say, and let's determine if what you're saying is reliable under the Daubert-Frye analysis. And here the courts have made great headway. And here's what they're coming up with. 1, you can testify, but you can only testify to one of the 5 conclusions you reached. I'm not letting you testify to the other 4 because I don't see where you've presented any documentation for that. Or, and this is a good one, this is brand new, the last couple of cases. In the first instance, the government must make a threshold showing on direct examination as to the scientific reliability of the evidence. Some of you may have heard this in law school and in state court cases as the burden of going forward. And where on direct they cannot do that, the judge says, we don't have to go any further. The hearing's over. This evidence is excluded. Or the witness is no longer going to be allowed to state absolute certainty. It's a match. It's consistent with. It's identical. I'm not allowing that. Or the witness cannot state, my method is scientific. No. Judge Rakoff, Southern District Judge, New York, very well versed in forensic issues, says, not in this courtroom. You're not saying that. And by the way, you're not even going to be allowed to testify that what you do is a science. In United States versus Malzone, the judge said, this is not science. It may be something else, but it's not science, and you're not going to say that in this courtroom. Fingerprints. Here's one judge who said, I'm not letting you testify that fingerprints are unique and permanent. There's a judge who bought the argument. He bought the whole argument, hook, line, and sinker, right? If you can't show me a study that says that, then you're not saying it. Pretty good. And finally, human error is involved in all determinations. These cases, particularly Malzone, Smallwood, and then the last case, and I'll end up with this, just came down, not in your outline, State versus Jabrocki, Jabrocki, Michigan, blood alcohol, Daubert case. Now here, we were dealing with a science that's accepted by the NAS. Blood alcohol testing, gas chromatographs. We get a reading. Here's what happened. It turned out, when they did the Daubert hearing, that the judge found out for the first time, and so did the defense, that the state crime lab had done 2 tests of the blood alcohol level. The first test came out 0.289. The second one came out 0.303. They never told anybody about the second test because their policy was to present a final lab report with only 1 test result, the lower. Well, wait a minute. Marv, what are you complaining about? They did the lower. How much fairer could they be? Here's the problem. The judge said to the state's expert, why is there a difference between these two? So I said, well, there's a difference because there's a thing called the error rate, or error budget, fancy term, but means the same thing, the error rate. So the judge said, what's the error rate? He says, well, that's something you can calculate. So the judge says, you can calculate it? Yes. He said, is that scientifically acceptable? He says, it's one of the bedrocks of science. So the judge said, did you calculate the error rate here? The guy goes, no. No. So now here's where a smart defense attorney earned their livelihood, and we should give this person a Champion of Justice award. Defense attorney said, and here's one of those cross-examination questions. We should debate this during the next 48 hours. It's one of those moments. Should you ask the next question, or should you just sit down and shut your mouth? The defense attorney said, I'm going for it. Not a reckless decision, a calculated one. Because he felt the witness was on the ropes. You know what that feeling is, right? I think I'm going to ask it. Well, were you told to do this error rate? Yes. Who told you? The ratings agency, Askeladd Lab. When did they tell you to do this? 18 months ago. 18 months ago, and you haven't done it? That's correct. Have you tested other cases in the last 18 months without doing the error rate? Yes, we have. So here was the question. Defense attorney to witness. What were you waiting for? Right? Open-ended question, right? You don't know what the answer is going to be. This is why we lose weight as defense attorneys. Right? It happens. You lose 5 pounds in a nanosecond. What is he going to say? This is what he said. I was waiting for the development of an alternative approach. How do you like them apples? And on that note, with that kind of answer, you should know that we can cross-examine these guys, we can do this, we can beat them at their own game, and we can win and stop this reckless business of wrongful convictions once and for all. It takes a lot of work, a lot of new partnerships, but it's doable. Thank you.